Order, order. I'd like to remind members to send their speaking notes to hansardnotes@parliament.uk, to switch off electronic devices and to abstain from tea and coffee. It is Lent after all. The government win.
Thank you, Mr. Desmond. I beg to move that the committee vary the resolution of the programming subcommittee as follows. In paragraph 1F, leave out the words and 2 p.m, thus removing this afternoon session. Thank you.
The question is that the resolution of the programming subcommittee be amended to leave out the words and 2 p.m. in paragraph 1F. As many are of that opinion, say aye. Aye. Of the contrary, no. The ayes have it, the ayes have it. We now come to clause 92, stand part of the bill. So the question is that clause 92 stand part of the bill. Minister.
Thank you, Sir Desmond. It is a pleasure to again serve under your chairship, and after that remarkably collegiate agreement on the most controversial, I hope, of today's business, I will turn to clause 92, which provides a vital safeguard for the new debt recovery measures as it inserts new section 80D into the Social Security Administration Act 1992, making provision for a code of practice. Within this clause, we have made it a requirement that the code sets out how and when DWP will exercise its functions under direct deduction and driving disqualification powers, as well as its approach to penalties for non-compliance by banks, and how any information obtained will be used and processed. The code will also include further information on how safeguards and other provisions contained within the bill will be applied, i.e. reasonable opportunity to settle the debt, and how those struggling with debt can be signposted to independent debt advice and money guidance. We recognise the importance of transparency in the use of the new debt recovery measures. This is why, before issuing the DWP's Debt Code of Practice for the first time, as per our statutory obligations, we will carry out formal public consultation on a draft of these codes to provide an opportunity for all interested parties to review. Once finalised, all the relevant codes of practice will then be laid before both Houses of Parliament for 40 sitting days before publication. Clause 92 is a key safeguard to ensure the new DWP recovery powers are exercised proportionately, and it offers transparency for the public on their use. Therefore, I beg to move that Clause 92 stand part of the bill.
Rebecca Smith.
Thank you, Sir Desmond. Clause 92 would require the Secretary of State to issue a code of practice about the giving of notices to banks requiring the provision of information, processing of information, circumstances when penalties may be issued to banks, and the circumstance when the Secretary of State expects to exercise the functions to disqualify a liable person from driving. As we have said several times throughout this committee, it has been extremely difficult to scrutinise this bill without the code of practice. So can the Minister confirm again, and I believe he just did, but we'll get it on writing from me, when that will be published? He's obviously said before it comes into the bill is laid fully, but ultimately it would be useful to know what sight we will have of that before the Act is finalised. And what can the Minister say about how the Code of Practice will regulate the giving of information notices to banks? We clearly agree that the Secretary of State should consult on the draft code, and the Minister has just implied that that will be a public consultation. It would be useful to know what form that will take and how that will be publicised to ensure that that can be seen by as many people as possible. And will it include a consultation on the impact of bank costs and what those should be, and give banks an opportunity to feedback at that point in time? Then the Secretary of State must consult before the first Code of Practice is issued, which is welcome, but there is no further suggestion that further revisions will be subject to any scrutiny. So can the Minister please confirm whether this is in fact the case? What oversight mechanisms exist to ensure that the Code of Practice is not changed for the worst in the future and ensure that Parliament remains informed? When does the Minister envisage the powers in the bill will first be utilised, given the delay that the Code of Practice consultation will necessitate? And what might trigger a revision and reissue of the Code of Practice? And who might be able to alert the Secretary of State for the need for this? It implies that the Secretary of State can do that, but what might be that trigger, and how and who could be involved? And will there be a non-statutory review after a certain period of time as an initial check and balance? Thank you, Sir Desmond.
Steve Darling.
Thank you, Sir Desmond. It's a pleasure to serve under your chairmanship. I'd like to thank the Minister for sharing his introduction into this item, his assurance that there will be a consultation. It would be really helpful if he could explain the likely consultees that he will be going out to. Also, in the code of practice, and it has been something that has been raised repeatedly from members on this side of the debate, what are the key principles within that consultation? If the Minister could share what the key principles are, what areas is he keen to address with the code of practice would be really helpful. He's alluded to some of this already, but a bit more flesh on the bone, Chairman, would be extremely helpful. I've raised this before, but often people who commit fraud use other people's accounts and abuse them, so there can be financial abusers. Can the Minister flesh out how the code of practice will take this into account? And then finally, Mr. Chairman, I'd be extremely grateful if the Minister could expand a little of the code of practice and how it will take account of people with learning disabilities, both people with learning disabilities who are able to operate the accounts themselves, but also people with learning disabilities who may need a proxy to manage that account themselves, and how the code of practice may, in principle, would take that into account. Thank you, Chair.
Minister.
Thank you, Sir Desmond. So there are a number of questions in there which I will do my best to cover off. In terms of the broader context and content of the code of practice, clearly the steps that I outlined in my initial contribution around reasonable opportunities to settle debt, around the exercise of functions under direct deduction, driving disqualification powers, penalties for non-compliance by banks, the use and processing of information, and ensuring how and where that is compliant with the Data Protection Act and GDPR, as one would expect. So a range of areas that would be covered by that. In terms of broader questions around how we would work with people with vulnerabilities, he mentioned financial abuse and learning disabilities. As I set out in some detail on Tuesday afternoon, there are a range of existing practices in terms of how the department supports people. We have a vulnerability management framework, and built into our existing debt recovery practices are assessments of an individual's vulnerabilities at all points throughout the process, including a specialist team that work with customers that we know to be vulnerable. So I think that we have sufficient infrastructure in place, both within and more broadly in the department, to deal with and support people who find themselves in those circumstances, either as victims of financial abuse or because of some of the disabilities that the Honourable Gentleman suggested. In terms of the issuing of notices, which the Honourable Lady asked about, it will give guidance on when notices are given, further guidance on how banks should comply, etc., etc. I think what it's important to say in terms of consultees, we're in ongoing dialogue both with banks and with organisations such as the Money and Pension Service around support for people who find themselves in debt. The public consultation will invite those who are already closely engaged with this to correspond with us further. So again, some of the stakeholders that I've just mentioned, but of course we will accept evidence from anybody who wants to feed into that process. In terms of future revisions, I wouldn't want to second guess what may be the cause of a future revision, but were it to become apparent either in discussion with stakeholders or in practical application of the code that there were issues that we needed to contend with, grapple with and put right, then I would imagine that would be a sensible stage at which to do that. In terms of delay and when the code would come into place, it is only 40 days that we are looking at in terms of how long it needs to be laid before both houses of Parliament. So I'm confident there that that delay will not be a particular challenge for us in terms of our ability to recover some of the figures that are scored against this particular measure with the bill. And finally, and as I always do when answering questions about the Code of Practice, in terms of when we can hope to see the draft, we anticipate that they will be available to members before committee stage at the House of Lords.
The question is that Clause 92 stand part of the bill. As many as are of that opinion, say aye.
Aye.
Of the contrary, no. And if the ayes have it, the ayes have it. We now come to the question that Clause 93 stand part of the bill. The question is that Clause 93 stand part of the bill. Minister.
Thank you, Sir Desmond. Clause 93 inserts new section 80E into the Social Security Administration Act 1992. This provision gives DWP officials right of audience and to conduct litigation in the magistrates, county and crown courts in England and Wales. New section 80E has been introduced to enable lay DWP officials to oversee civil claims and applications and appear in related court hearings on behalf of the Secretary of State in debt recovery matters. This is similar to the rights already provided to other government departments such as HMRC, Child Maintenance Service, as well as local authorities. The disqualification from driving power in Clause 91 and Schedule 6 of this bill will only be exercised by the court on application from DWP, and there are other civil recovery mechanisms already available to DWP, involving the courts. These are generally routine proceedings, but without this clause, DWP is required to instruct a solicitor in every case. However, this clause does not prevent DWP from instructing a solicitor for debt recovery proceedings where it would be appropriate to do so. It ensures that DWP can recover public money from those who evade repayment in the most efficient and effective way, reducing costs for the taxpayer. And on that basis, I beg to move that Clause 93 stand part of the bill.
Rebecca Smith.
Thank you, Sir Desmond. Clause 93, as the Minister has just set out, grants rights of audience and rights to conduct litigation in the Magistrates' Court, County Court and Crown Court in England and Wales for or in connection with debt recovery proceedings to designated officers of the Secretary of State. This will allow DWP officials to be able to pursue the enforcement of debts via the court without the need to instruct solicitors, thereby ensuring cost efficiency in the recovery of public funds. So it's not a particularly complicated clause here, but just a few questions, if I may, Sir Desmond. We'd like to confirm the level of seniority the officials signing off the decisions to bring litigation will be. And I suppose the supplementary question to that is, will DWP officials bringing the cases have appropriate training to do so? And then where court appearances are required, does the Minister anticipate a slowing down of recovery proceedings? I know he's talked about cost efficiency, but does it mean that it's going to take slightly longer? And then does that actually by nature increase costs as a result, either in terms of what is owed by the person that the action is being taken against, or in terms of the costs that might be necessary through the courts? And finally, Sir Desmond, what consultation with the Ministry of Justice has taken place around these new provisions in terms of capacity and the costs and the fact that the courts are already backlogged, and is this going to add a particularly problematic situation, or are you confident that this is something, is the Minister confident that this would be okay going forward? Thank you.
Minister.
Thank you, Sir Desmond, and forgive me, I may have missed a question about costs, so please do come back in if needed. In terms of the seniority of members of the team who would be taking forward cases for us in the court, they would be of HEO level. That's the existing process in place and the existing level of authorisation where we already have similar powers. This is not particularly new for us, it's just new for us in this particular space. So it will be a specialised team within DWP who will receive training in conducting litigation, as you would expect, and appearing in court, as one would expect, and appearing in court, in addition to training on the new recovery powers. As I say, we already have the right to conduct and appear in similar tribunal proceedings, so we would, of course, share best practice when developing this training. On the question of MOJ consultation and court pressures, I think it's fair to say that whether we're using a solicitor or whether we're taking these forward ourselves, the pressure on the courts would be the same, and so I don't consider there to be a material difference in the way that that impacts on the court backlog. Clearly the MOJ are aware of our intentions in this regard, but this is more about our ability to do that whilst minimising costs. And if there was a further question around that, please do intervene.
I'll intervene if I may, thank you. The further question, or the final question, was more about the whether court appearances, regardless of whether that's with a solicitor or through these DWP officers, will effectively slow down recovery proceedings, and whether as a result there are some unintended, well not unintended, but some knock-on costs, either to the person that the action is being taken against, if interest is being charged or anything like that, or in terms of the cost to the department, I suppose, in staff and that sort of thing. I'm assuming this will be a last resort, but it would just be interesting to have an answer.
So, thank you. The question of this being a last resort, very much the case. So, where there are additional costs, we will be able to recover those. I think it's important to recognise the steps, as I outlined on Tuesday afternoon, that would have been gone through before the point at which we reach this process. But were we to go through a more traditional route outside of these powers, I think that would add more considerable time to the process. Just a reminder for members that by the point at which we are taking somebody to court, we have reached out to them multiple times through debt management, at least 4 further times through debt enforcement. We have offered at every break in the process the opportunity to agree an affordable repayment plan. That would be the case right up until this stage. So to assure members, yes, exactly that, it would be a power of last resort.
The question is that Clause 93 stand part of the bill. As many are of that opinion, say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. We now come to the question that Clause 94 stand part of the bill, with which it will be convenient to debate Clause 95. The question is that Clause 94 stand part of the bill. Minister.
Clause 94 inserts Section 80F into the Social Security Administration Act 1992 and relates to recovery of costs from debtors, which we were briefly just discussing. This clause simplifies existing legislation to ensure the costs of court enforcement, which DWP is already entitled to reclaim from debtors, can be effectively recovered from the debtor, together with any costs incurred by DWP under the new direct deduction and disqualification from driving powers. The clause enables DWP to recover these costs from the debtor using any of the available recovery methods to make sure that as debtors' circumstances change, this money can still be recovered. This clause ensures the taxpayer does not pick up the burden for costs associated with pursuing debtors who refuse to repay public money, and that DWP can recover these costs from the debtor in the most effective way. Turning then to Clause 95, this inserts new Section 80G into the Social Security Administration Act 1992, providing technical interpretive powers, provisions for the new debt recovery powers contained in Part 2 of this bill. Firstly, it confirms that debt recovery provisions should always be read in a way which is consistent with data protection legislation. This is a relatively standard provision that deals with any unintended and unforeseen ambiguity or apparent conflict with normal data protection principles. Secondly, it confirms that references to giving notice can include, amongst other methods, service by post, as defined in the Interpretation Act 1978. This avoids ambiguity about how, for example, proposed deduction orders can be given to account holders for their consideration, which is a key safeguard under the new direct deduction power. So, having outlined the purpose and content of clauses 94 and 95, I beg to move that they stand part of the bill.
Rebecca Smith.
Thank you again, Sir Desmond. Clause 94 states that any costs incurred by the Secretary of State in recovering an amount under clauses 71 to 80 or Schedule 3ZA or 3ZB of the Social Security Administration Act 1992 may be recovered as though they were recoverable under the same methods as the debt itself. So 2 brief questions on this point, if I may. Will this be done separately? What might the cost to the department be in putting that forward? And is there any limit to the costs that the Secretary of State can recoup in this way? And then Clause 95 clarifies that provision does not require or authorise processing of information that contravenes data protection legislation or the Investigatory Powers Act. The final line states that references to giving a notice or other document include sending the notice or document by post. Now, this was something that came up earlier on in the conversation on Tuesday. So just to, again, to get it on the record, can the Minister clarify if this is the only method? I presume I know the answer to this question, but I'm going to ask it anyway. Does it include electronic methods of communication, such as email too? But actually, if I may, Sir Desmond, just for my own information, why does sending by post need separate legislation? I'm intrigued because we've debated this twice now, and it's probably a really straightforward answer, but I figured seeing as it's in there as a line on its own, it might be a nice idea to find out why it has to be legislated for, purely just because I'm nosy and I'd like to know. Thank you.
John Mill.
Thank you, Sir Desmond, and it's a pleasure to serve under your chairmanship. Clause 94 states that costs incurred by the Secretary of State in taking recovery actions can be themselves recovered. Can the Minister give clarity on what happens in a case where the person, the claimant, is found to be not guilty? What happens to the costs then? Are they borne by the bank, by the DWP, by the claimant? If he could clarify that. And for that matter, perhaps the cost of the general trawl through all the accounts. Can you give clarity on how they are apportioned? The second point is going back to this issue of fraud versus error and the way that they seem to be treated as pretty much the same thing throughout the bill. Can the Minister give clarity on would a claimant be charged in a case where again when he was guilty by error, would he still have to pay costs on that? Or sorry, if it was guilty of a DWP error, would the claimant end up paying the administrative charge of a DWP error, which seems quite unreasonable if that is the case. So if he could give clarity on those points, that would be great. Thank you.
Thank you, Sir Desmond. I'm a little perplexed by the suggestion that somebody would be found not guilty or be charged. It's a debt recovery that we're talking about, so it's a slightly separate matter. It's not a criminal issue. It is a question of how, through civil powers, we are able to reclaim funding. So I'm not sure that those questions arise, but if the honourable gentleman does want to come back, please do. On the question of whether or not fraud and error are distinguishable in the reclamation of debt, no. They are treated in the same way, because this is about somebody who, it is already established, owes us a recoverable amount and has repeatedly refused to engage and to do so. I refer to my earlier comments about the number of times that we would have reached out to somebody in order to attempt to get them to engage with that. Parliament has previously resolved that overpayments of certain types of benefits are recoverable, and this bill does not change that. In terms of the savings, etc., so we would be able to recover all reasonable costs. There is no particular limit on what we can recover there, and it's on the same terms as debt in that basis. On the question of why we need to distinguish for email, this is one of those where I am very, very grateful that sometimes I can reach out for answers, but it goes back to the Interpretation Act 1978, because back then we did not have email, so we need to just set out separately on a legal and technical basis that post is specifically allowed given provisions elsewhere. But yes, digital is still permissible, but we do need to state specifically that post is acceptable as well.
John Mill.
Thank you, Sir Desmond. If I may come back on the issue of guilt. Forget the word guilt, remove that. What I mean is, in a case where a claimant was investigated, so costs were incurred, but it turned out that there was no fault, basically. Let's remove the word guilt.
So I think the honourable gentleman is referring to, were the court to determine that the debt is not recoverable, then at that point I would imagine that we would be bearing the costs of that ourselves. It wouldn't be recoverable from the individual at that point. Clearly, there is some risk for us in that, as is perfectly usual. But by the point at which we had reached that question of needing to take somebody to court, we would be able to demonstrate a significant amount of effort had gone into attempting to make them pay back what they owe to the department through other mechanisms. So I would hope that we would have a very high success rate in that regard.
The question is that Clause 94 stand part of the bill. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. We now come to the question, let Clause 95 stand part of the bill, which has just been debated. The question is that Clause 95 stand part of the bill. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. We now come to Clause 96 stand part of the bill. The question is that Clause 96 stand part of the bill. Please.
Thank you, Sir Desmond. Clause 96 amends sections 111A and 112 of the Social Security Administration Act 1992 to include non-benefit payments. Doing so will enable DWP to charge a person with an offence under either of these sections where it relates to a non-benefit payment. This is a key clause. In conjunction with Clause 97, it will enable the Department to offer an administrative penalty where there are appropriate grounds to do so. This government's approach to tackling fraud and error is one of fairness and proportionality. We will always be tough on serious fraud. However, for less serious, first-time offences, it is appropriate and fair that we have the opportunity to offer an alternative to prosecution. The person will always have the choice to accept or reject an administrative penalty should they wish to do so, and I beg to move that Clause 96 stand part of the bill.
Rebecca Smith.
Thank you, Sir Desmond. Clause 96 makes it an offence for a person to fraudulently claim a non-benefit payment for themselves or another person by making false representations or documentation. Generally, we support this provision. A non-benefit payment is a prescribed payment that is not a relevant social security benefit and is made by the Secretary of State to provide financial assistance. However, just for the record, and whilst we're debating this morning, could the Minister please provide some examples of the sorts of types of payment that would fall within scope of the bill as a result of this additional measure? And can the Minister reassure us that this will cover all payments, unlike social security benefit, which is only the 3 included in the legislation? So I suppose the flip question is, are there any exceptions that he would anticipate not being covered? And would the announcement of any non-future benefit payments, or the introduction, I should say, of any future non-benefit payments automatically fall within scope of this legislation? Again, I know we debated similar things earlier on in the committee proceedings in terms of enabling new benefits to come into scope in the future, and I was wondering whether the same would be the case if new non-benefits came into fruition as well. Thank you.
Mr. Darling.
Thank you, Chairman. And I would just be really grateful where the Minister alluded to showing proportionality, not wanting to criminalise people and undertaking an administrative charge. I would, as my colleagues had already alluded to, it'd be really helpful if you can just unpack that a little bit more for the committee of where proportionality kicks in would be really helpful. Thank you, Chairman.
Minister.
Thank you, Sir Desmond. So in terms of where proportionality kicks in, this is established already within the department, and we have trained investigators who look at and ascertain whether we are looking at deliberate fraud, the severity of that fraud, and therefore the appropriate mechanism through which to seek recourse for that fraudulent activity, because where we're talking about administrative penalties, this is where we consider it to be a clear case of fraud, not of error. So it doesn't really change within the bill. What is changing is our ability to extend those existing processes to non-benefit payments. And in terms of what some examples of those might be, the example that we use most routinely is Kickstart, that came about at the end of the pandemic, which was, I think it's fair to say, open to abuse, and we did see some particularly egregious examples of that. So we would want to make sure that any similar grant grant schemes rather than benefit schemes themselves are also in scope for these powers. Just on the point that the Honourable Lady made about only 3 benefits being in scope of this bill, just to be really clear, that's only as it pertains to the eligibility verification measure, but all benefits are in scope of the bill more broadly. The question about benefits coming, grants coming in and out of scope of the bill, so we will be able to prescribe in regulations which non-benefit payments will be within scope of the power. Access to work will be one of the first to be included, and we will consider others on a case-by-case basis as new payments are introduced. It's something that we need to retain some flexibility about, but to support that on a case-by-case basis, the Department would always conduct a fraud impact assessment, which has recently been introduced to assess the fraud and error risk within any such non-benefit payments. So there'll always be a structure in place to see whether these non-benefit payments will be suitable for this power.
The question is that Clause 96 stand part of the bill. As many as are of that opinion say aye.
Aye.
The contrary, no. I think the ayes have it. The ayes have it. We now come to the question that Clause 97 stand part of the bill. The question is that Clause 97 stand part of the bill. Minister.
Clause 97 amends the Social Security Administration Act 1992 to expand the types of overpayments that can be considered for an administrative penalty under sections 115A and 115B to include non-benefit payments such as the grants that were paid through the Kickstart scheme. Currently, the option to offer an administrative penalty as an alternative to prosecution is not available for non-benefit payments. This, therefore, requires DWP to refer all such cases for prosecution. By extending the scope to include non-benefit payments, DWP can offer those receiving a non-benefit payment an administrative penalty in appropriate circumstances as an alternative to prosecution. This measure gives individuals or colluding employers the choice to accept the administrative penalty or have the evidence reviewed before the courts. This change is really about fairness. It will bring equity and parity to the way the Department tackles and addresses fraud, and it will offer those first-time offenders or those committing low-value fraud with an alternative to prosecution. This will provide the individual or colluding employer with a choice, allow the courts to focus on the most serious crimes, and enable the Department to resolve cases more quickly where it is appropriate to do so. And so I beg to move that Clause 97 stand part of the bill.
Rebecca Smith.
Thank you, Sir Desmond. So Clause 97, going back in time, makes provision to allow for a penalty to be issued instead of prosecution where an overpayment notice has been issued in relation to non-benefit payments. This can only occur after the review period has passed and if a review was sought, a decision made and any subsequent appeals concluded. We support efforts to be tough on those who have taken advantage through fraudulent methods and gained from benefits they were not entitled to receive. So can the Minister explain in what circumstances a penalty rather than prosecution would be deemed more appropriate and why that may be the case? That said, we also do not want to unfairly hit those who have made a genuine error. So in what circumstances would a penalty be seen as appropriate, assuming the claimant is engaging with the process that they have been made that has been brought to their attention? Has any consideration been made of the likely timescales in the repayment of monies obtained following erroneous claims? So how long does that person have? And would a repayment be allowed before a penalty is applied? Now, from what the Minister has just outlined, I think the answer to that is likely to be yes, because an entire process would have taken place first. But just seeking clarification on the timetable or the process involved, particularly for those who have made a genuine error and where they are able to sort of stop this train and make sure they can settle what they need to settle without getting any penalties as a result of their actions. Thank you.
Minister.
Thank you. So in terms of when a penalty is considered more appropriate, there are clearly thresholds in terms of our investigators' interpretation of when somebody has committed fraud, at what level we consider that fraud to be. But just with the point that the Honourable Lady made towards the end about genuine error, this is where we consider that somebody has committed fraud, not error. The administrative penalty does not arise in cases of what we consider to be error after we have given consideration to the case. So it may be that it is a first-time offence. It would certainly need to be a low-value offence because the limit of an administrative penalty is capped at £5,000, and it is worked out on being 50% of the value of the overpayment. So it would always need to be below £10,000. Anything beyond that, we would be looking at prosecution. In terms of how long to pay back, I mean, this would depend on a range of factors, clearly dependent on somebody's ability to pay that back, what the means of deduction is, etc., etc. So that would always be on a case-by-case basis.
The question is that Clause 97 stand part of the bill. As many as are of that opinion say aye.
Aye.
The contrary, no. The ayes have it. The ayes have it. We now come to Government Amendment 36 to Clause 98, with which it will be convenient to debate Clause 98. I call the Minister to move Amendment 36.
Thank you, Chair. And with permission, I will so move Amendment 36. This amendment is, I hope, a straightforward one. It is a minor and technical change and looks to update Section 6B of the Social Security Fraud Act 2001 by removing one phrase, the corresponding provision, which will no longer be needed should Clause 98 be made, and substituting in appropriate wording. Section 6B, as enacted, references two acts where a penalty is defined in legislation, and that would attract the loss of benefit penalty. The first is the Social Security Administration Act, and the second is the equivalent legislation for Northern Ireland. Clause 98 will remove reference to one of these acts, the Social Security Administration Act 1992, to ensure the loss of benefit sanction is no longer applied where an administrative penalty has been offered by DWP and accepted by a benefit claimant. Doing this simply means there would no longer be corresponding legislation in Section 6B2A of the Social Security Fraud Act 2001, as this will only reference Northern Ireland legislation. I can assure the House it will have no operational impact on the remaining provisions in the Social Security Fraud Act 2001 and is minor and technical. Therefore, I beg to move this government amendment. Moving then to Clause 98. This clause removes the loss of benefit provisions in cases where an administrative penalty has been offered and accepted as an alternative to prosecution. As it stands, the acceptance of an administrative penalty is compounded by a further 4-week suspension of certain benefit payments. This suspension of benefits is made in addition to the acceptance of the administrative penalty and alongside the obligation to repay the overpayment. By removing the 4-week loss of benefit in these cases, this clause allows for a more proportionate approach to less serious, lower value fraud and to first-time offenders. However, the loss of benefit penalty is not being removed in its entirety. The loss of benefit penalty will still apply in cases that are convicted in court, where a loss of benefit of up to 3 years can apply. Limiting the loss of benefit penalty to convicted cases will ensure only the most serious cases of fraud face the harshest consequences without imposing unnecessarily harsh sanctions on lower level offenders. And on that basis, I beg to move that Clause 98 stand part of the bill.
Government Amendment 36 proposed to Clause 98 as on the amendment page. The question is that the amendment be made. Back to Smith.
Thank you, Sir Desmond. Clause 98 amends the Social Security Fraud Act so that if an administrative penalty is accepted instead of prosecution, the individual does not lose their benefit provisions. Although, from again what the Minister has said, it sounds like there are still different scenarios that are affected. I appreciate what the Minister has just said in terms of the different situations. So, for a lower level, for somebody's first-time offence, they might not be in that position to lose their benefits. I suppose there is just perhaps of a challenge that this seems a little bit of a soft touch still, depending on the situation. And does there not need to be a bit more discretion than just a sort of threshold, depending on each case that is being dealt with? And what are the expected values of the penalties, and how does this compare to the typical benefits as well? So while we need to ensure that safeguards remain in place around affordability and ensuring that claimants can meet their essential living costs, that absolutely goes without saying, it is not clear why a penalty should automatically prevent the loss of benefits too, because ultimately these situations, there's got to be a deterrent in there as well that is in addition to the penalty. Government Amendment 36 updates the Social Security Fraud Act 2001 to allow a penalty to be an alternative to prosecution in Northern Ireland, and our questions on this would be the same as those in Clause 98. I don't have anything further to add. Thank you, Sir Desmond.
Sarah Berry.
Thank you, Chair. It's a pleasure to be moving very minor amendments under your chairship today. I just wanted to point out, in terms of the wording of Amendment 36, that on line 21 there are 2 instances of A in brackets in the way that it's spelt out there. And I know which one you mean, which one the government means, but I just wondered if potentially the wording of the amendment could be clarified. Thank you.
Can I thank the Honourable Lady for pointing that out? I will take advice on whether a further amendment may be required in future, but as she says, it does appear obvious what I mean when I make references to that. To the comments from the opposition spokesperson, the member for South West Devon, we do want to make a change so that it is only the most serious cases that fall foul of the loss of benefit penalty. Clearly that would increase hardship for people, but in terms of our ability to reclaim money as well, in practical terms, it means that we would wait 4 weeks before we could start deducting from that person's benefits. But just to give some reassurance about thresholds, were we to consider that somebody's fraud, even in a lower value case, was particularly outrageous, and of course that is a judgment for our investigators based on the sorts of things that they see each and every day. We do retain the ability to go straight to prosecution, particularly if we think that it is, for instance, part of something that is more serious or organised. In terms of the value of the penalty, that's £65. But clearly, at the moment, if you're losing 4 weeks' benefit, then that is a more significant impact. I accept that, but I just think that there is a strong question of proportionality here and preventing somebody falling into further poverty and potentially, as a consequence of that, being pushed into wider activity that may be, shall we say, unhelpful.
Government Amendment 36 proposed to clause 98. The question is that the amendment be made. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it, the ayes have it. We now come to the question that clause 98 as amended stand part of the bill, which has just been debated. The question is that clause 98 as amended stand part of the bill. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it, the ayes have it. The government whip.
So I beg to move that this committee do now adjourn.
The question is that further consideration of the bill be now adjourned. As many are of that opinion say aye.
Aye.
Of the contrary, no. The ayes have it, the ayes have it. Order.